Sex Offenders Register for purposes of monitoring their activities has been launched by the judicial system, designed to allow government and authorities to keep track of the offenders and activities of sex offenders, including those who have concluded their criminal sentences.
In many jurisdictions, registered sex offenders are subject to additional restrictions that do not apply to other probationers. Sometimes these include or have been proposed to include restrictions on being in the presence of minors, living in proximity of schools, even holding toys that are of interest to children, and even using the internet. In other jurisdictions, the burden is on the sex offender to register themselves to a local authority, and in other jurisdictions, the public body is to keep track of these sex offenders.
However, the Sexual Offences Act of 2006 provides that any person who has reasonable cause to so examine the register may examine it, but the law stipulates that the one has to apply to the registrar to access the list.
It is therefore not open to public viewing and scrutiny, but is available whenever required for legitimate reasons. Other jurisdictions which have similar restricted viewing, we can give you examples of institutions which may want to examine such a register. For example, the Teachers Service Commission, before they hire primary school teachers or teachers who will be around children, the Public Service Commission for hiring people in certain institutions, even the Judicial Service Commission, and as the Attorney General indicated, even the Independent and Elect on Boundaries Commission.
In this regard, the judiciary, in compliance to the law, is in the process of developing an automated database that captures the details of the sexual offenders.
In this database are the name, the identity card number, the date of conviction, the nature of the crime that the person has been convicted with, the age of the victim, and the rehabilitation details of the accused person. The Chief Registrar will then have administrative rights together with the rest of the team who will have been given this permission to access the system.
It is, however, evident that the sexual offences, more than other criminal matters, require delicate handling across the entire justice chain. There are several stages towards comprehensive justice delivery, resting on the shoulders of different institutions.
Mwenga's story, just tells us how these cogs of the same chain never work in tandem. And the result is that we always blame the one of the cogs. If one of the cogs is weak, then the entire delivery of justice will be compromised.
Both the police and the health statistics in Kenya reflect a high incidence rate of such offences, rating sexual offences only second to common assault. The judiciary is therefore working on a comprehensive curriculum and a manual for training of judges, magistrates and other staff on the Sexual Offences Act. Violet Makendo, GBS News.